not be and be capable of safely operating a vehicle if
That's
you're below the legal limit.
not in Midlands. If you read the case, it's all that you have to prove a DUI is that he was under the influence of alcohol.
Well, you've got to have a certain level of alcohol. And even if you have that case there, the judges don't want to know that. Kim, the photos and everything, did you introduce a smaller version of the photos?
No, because I don't
Okay.
have. I mean, I have them, but like you know how they're all doubled up and stuff.
Yeah.
I just get some lumps and that.
Make sure you identify each photo.
Yeah, and if you are going to introduce them into evidence, which is good because you get points for introducing it, don't do the blow up first that everybody sees.
Yeah.
Yeah.
Handy one and say, what is this? You know. Yeah.
Okay. The best way to do it is you introduce the small version of the photo.
Into
Okay.
evidence, like, but I actually
Yes.
put them in evidence.
And identify each and every one of the small versions of the photo.
Okay.
And introduce them to evidence. Then hopefully pre-trial, everyone has talked to opposing counsel and they've asked opposing counsel, can we stipulate that this is an accurate enlargement as it is set portrayed? And then you can turn to the judge and say, Your Honor, prior to trial, we stipulated these are accurate, that we have some enlargements. Those enlargements are accurate enlargements of the exhibits we just introduced into evidence may have published to the jury. Otherwise, you have to go through the whole.
You said stipulate in pretrial?
Yeah, do that at pre-trial and talk to the other team and say, yeah,
Hey, we've got the photos. Can we just go ahead and stipulate that these are accurate enlargements?
right.
But all attorneys, when you introduce a photo, you don't have to go into nearly the foundation that Kim laid.
Yeah.
Basically, all you have to do is establish that the person is familiar with the subject of the photo and that that's how it looked at a certain time. So basically, all she has to ask the officer is, is that the way it looked that night? And if he says yes, it's admissible.
I wouldn't do that.
Now, there's some photos that are taken after the date, but what you could do in those cases are, where these photos, do these photos appear as they appear on the night of the accident? Well, they weren't taken on the night of the accident, but to my knowledge, nothing has changed in those photos
Yeah.
from the time of the accident.
Yeah.
Okay, offer them to evidence.
And that's all you need. It doesn't matter who took them. It doesn't matter when they were taken. Just as long as they represent the way he saw it that night.
Board diary, Brian, I had it down, you had a pretty good board diary, shorter than Grady's, it was good, but
Yeah, I wish I would have had him last week instead of you.
huh?
Nathan kept it out for like 3 hours last week. He was great. Ridiculous.
We've got, the main thing on cross is you gotta know your affidavit cold, you gotta know those reports cold, you gotta know everything just absolutely. And when they ask you a question that he's gonna have to pin you down on, it's like what Coach D said, he's getting points if he has to stay on you and he eventually gets that answer from you. He doesn't get as many points if you just say, yeah, that's correct. And if you act like it doesn't hurt you, jury doesn't know it really hurts that bad. If you gotta answer it a certain way, go ahead and answer.
But when there's a long fight, then the jury gets they perk up and they're like, hey, this must be important, So.
And the attorney wins the fight.
Like when he said, there's dispute about, or the drag sled thing. All you have to say that doesn't answer either way is, well, there is debate about whether or not it's accurate. That answers this question. That doesn't really admit one way or the other. Yes, there is scientific debate about whether or not it's accurate.
But that's not, because I want to get, it really says there's no research to show that this result are accurate. That's what I was getting to, and I didn't know why you let it in.
Make sure you review that
Well,
article.
yeah.
Yes, that's where it is. Right.
Yeah, it's at the end of that article.
But the thing is, in reality, the judge is still going to let it in, but it's your job then to say, officer, there's no, on cross, there is no scientific backing to this, is there? Yet you still relied on it, and then in closing, you just hammer it. Hey, he got up and told us there's no scientific backing for it, and he still relied on it. We can't listen to anything he says.
That was my question, is should I have gone back into my same voir dire stuff on cross?
Unless technically a voir dire is outside the.
Yeah, it's outside the hearing of the jury.
So unless we did something like we did last week, I think I asked Grady, do you want that voir dire to be considered to be questions that you've asked in front of the jury after you got done with your voir dire? Unless that's happened, I would go ahead and go into it. Or what do you think about this, about just asking the judge, can we just consider the voir dire that I've gone into as conducted in front of the jury, so that I don't have to rehash the same ground?
Yeah, that would be fine. In real life, it wouldn't happen, the judge won't allow it, but it shows the judge, hey, I know that that wasn't in front of the jury. So,
At this time, Your Honor, I make a motion that the board diary did be.
no, you can't. You can't. AMPA doesn't allow motions.
Yeah.
But what you can say is, Your Honor, can I ask your preference? Can we consider that board diary as being in front of the jury, or would you like me to go back into it again? You know, and 9 times out of 10, the judge is going to say, no, don't worry about going back into it. Okay.
The response, and the only other thing I had is the response to why, the statement by the prosecutor, why it's relevant. The relevance doesn't depend on its truth. It depends on the effect it had on law enforcement, in that it simply put pressure on them to find something, whether it was there or not. And that's all I would say on the response. I think that's a pretty succinct way to say it, and I think that fairly clearly puts out there why it's relevant.
Okay.
But when I asked you about the, I said, I don't know what the statement is, give me what he's going to say, make it even more simpler and just say that, he's going to say, the prosecutor said, I'm going to make his life a living hell, and then I expect that the witness will testify. Because of that, he acted in this way. Therefore, and keep it nice and short and easy for a judge to remember 15 years ago in law school when it's like, oh yeah, they are allowed to do that. Because half these people that you get for judges aren't practicing, I mean, they're attorneys, but they do divorce work or real estate closings or something like that, and so they don't remember the rules of evidence.
I just like talking lawyers.
All right, final witness for the state.
Prosecution calls Dr. Avery Smith.
All right, Dr. Smith.
Dr. Smith, can you please introduce yourself to the court?
Hello, good morning everyone. My name is Dr. Avery Smith.
What do you do for a living?
I am director of the forensic department at Midland State headquarters, and
What qualifications do you have to do that job?
I graduated from Gonzaga University. I received a degree in biochemistry, then I went on to Seattle University and received a degree in public administration. Then I went on to the University of Washington, where I received a degree in public health and a PhD in biophysics.
What is your work experience?
I worked for the Midlands Department of Forensic Science for most of my career. I started off as a breathalyzer analysis, and I became director of toxicology in 1990, and finally became director of the forensic department in 1995.
What exactly do you do as the director of the forensic department?
I'm mainly in charge of supervising and conducting scientific research, but when the time arises, I sometimes provide analysis of people's blood alcohol content, obviously.
How did you become involved in this case?
I became involved on the night of September 25th, 2010, when the defendant, Donnie Dawson, was brought into my office. He was suspected of being under the influence of alcohol.
How do you tell whether someone is under the influence or not?
We use a breathalyzer. It essentially can tell us if someone is over or under the legal limit.
What kind of a breathalyzer do you use?
We use the Intoxilizer 8000.
Is this machine approved by the scientific community?
Yes, it's the standard in our field. It's used by over a dozen states, and it's been found to be very reliable.
Is it both precise and accurate in the measurements it makes?
Yes, the results are very valid.
Has it been peer reviewed?
Yes.
Is there an error rate?
Yes, but factors such as malt alcohol can account for an error rate, but when the proper procedures are followed, it's negligent.
Can you tell us what is mouth alcohol?
Malt alcohol are factors such as that can be accounted for by breath means or gastric events, but we have a standard procedure of waiting 15 minutes, and during this time, if malt alcohol is present in a person's mouth, it would have vaporized, and those procedures are followed, malt alcohol will not be accounted for.
When Mr. Dawson arrived at the station, or Miss Dawson arrived at the station, excuse me, did you follow this procedure?
Not personally. Officer Foster had watched the suspect for 20 minutes prior to examination, and I also interviewed the defendant, Donnie Dawson, for an extra 5 minutes.
Now, when you interviewed Miss Dawson, how did she sound?
She had slurred speech and talked really loud.
Are these indicative of a person who is under the influence?
Objection, Your Honor, proper opinion.
May I respond, Your Honor? This is an expert witness who often determines whether or not someone is intoxicated or not, and therefore he is qualified to say whether or not someone's actions are consistent with being intoxicated or not.
Your Honor, if I may.
Yes.
This expert witness is an expert in using breathalyzer tests to determine whether or not they are intoxicated. What the question is pertaining to is behaviors, which Dr. Smith is not an expert in.
May I respond, Your Honor? Because he conducts these tests, and because he's often in contact with people that are intoxicated, he is qualified to testify how people that are intoxicated generally act. Therefore, he can answer this question in a professional opinion.
All right. I would agree with everything you said there at the end if it comes from the witness. So the objection is sustained for now, and he will not be allowed to answer it unless you establish that he is around drunks or is around intoxicated people a lot, is familiar with their behavior, and then can give his opinion on it. All right?
Motion to strike.
Well, he didn't answer. Yeah.
Dr. Smith, are you often associated with people who are intoxicated?
Yes, very much. I have conducted this test several times, and several times multiple people have been found drunk, and I'm aware of their behavior.
So do they exhibit a consistent behavior when they're intoxicated?
Objection, Your Honor, proper opinion.
In the future, lay a little bit more foundation, although I think in theory that was enough, but let your witness shine and say, you know, like he said, I've given this test several times. How many times have you dealt with at least 30, maybe 50, 100, you know, something like that. But this witness is qualified to give an opinion on whether or not he thinks slurred speech is indicative of somebody that's been drinking. So, overruled.
May he answer the question?
Just repeat the question.
Dr. Smith, are there general behaviors that people who are intoxicated exhibit?
Yes. Behaviors such as slurred speech, stumbling, are indicative of someone who is drunk.
Did Ms. Dawson exhibit any such behaviors in your conversation with her?
Yes, on the night of September 25, 2010, Ms. Dawson exhibited slurred speech and was talking very loudly.
What did you do prior to the administration of the Intoxilizer 8000 test?
I talked to her for 5 minutes, and then I calibrated the machine to ensure that it was accurate.
Did you then conduct the test? And if so, how did you do it?
I obtained 2 samples from the defendant, Donnie Dawson. Then I ensured that the air blanks were in place, ran the test, and made sure it was properly calibrated. And I obtained the results from the 2 samples I obtained from the defendant.
Did you prepare reports concerning this test?
Yes.
Your Honor, permission to approach opposing counsel.
You may.
I am showing opposing counsel what has been pre-marked as prosecution exhibits 1 and 2. Your Honor, permission to approach the witness.
You may.
I'm showing the witness the same. Can you tell us what these are?
These are the reports required by the Department of Forensics in calculating someone's breath alcohol content.
Are they fair and accurate copies?
Yes.
Have they been tampered with or modified in any way?
No.
Do you make and keep these records as part of your regular business practice?
Yes.
Are you the custodian of these records?
Yes.
Did you make and keep these records at or near the time that you administered the test?
Yes.
Your Honor, motion to admit what has been pre-marked.
Objection, Your Honor, proper opinion.
How so?
The witness did not follow principles and methods reliably.
Your Honor, I believe the foundation has been laid.
Your Honor, if allowed to retire, I can show that the witness did not.
What is it that you contend is in these documents that is improper?
The observation window. or the pre-test observation period.
Do you have a copy that I can see?
This is-
Yes.
All right, so you're saying that the top portion, check mark pre-test observation period,
Mhm.
is improper. Give me just a second. All right, I did hear the witness testify about this particular issue. Why is this improper?
Because, Your Honor, that is an operator checklist, and he testified that someone other than the operator is the one who fulfilled or attempted to fulfill the observation period.
All right, well, this says nothing about the fact that the operator actually observed the person. It says that the operator is sure that the subject has not. I mean, it says the operator has knowledge that the person has not. He testified that, he did have knowledge of that.